So we're going to get started for the sake of time. We have one very short hour to talk about a lot of things. This panel is called 1 Year Later, Lessons Learned in the Aftermath of Dobbs. I would like to introduce our wonderful panel and myself. My name is Jenny Ma. I use she, her pronouns. I'm a senior counsel at the Center for Reproductive Rights, which is a global advocacy organization. And I am in the U.S. litigation program. I litigate in state and federal courts against abortion bans and restrictions. I have litigated all across the South and Midwest, including in Mississippi in the Dobbs versus Jackson Women's Health Organization case, and many of the cases that we will be talking about as well. I will start here to my left and your right. I have the distinct pleasure of introducing this panel of experts. And to my left is Melissa Torres Montoya. She's a senior manager of lawyer engagement at If, When, How, a nonprofit organization of lawyers aiming to transform the laws policy landscape surrounding abortion rights and reproductive justice. If, when, how to create, define, and sustain their families. Melissa is a reproductive justice and sexual health advocate who has dedicated her entire professional career to addressing the lack of healthcare equity, affordable quality healthcare in the U.S., and advancing sexual and reproductive autonomy. Further to my left is Professor Maya Manian. She is a professor of law and faculty director of the Health, Law, and Policy program right here in DC at American University, Washington College of Law. She teaches courses on constitutional law, public health law, and reproductive health care, and has also taught family law and contracts courses and rights in those areas prolifically as well. Professor Manian is also a nationally recognized expert on reproductive rights and justice. And last but not least, finally to my further left is Carrie Flaxman. Carrie is a senior director in the public policy litigation and law department at Planned Parenthood Federation of America, or PPFA, where she challenges restrictions on access to reproductive health care around the country, advises Planned Parenthood affiliates about the legal issues raised by restrictions, and assists those affiliates in developing advocacy strategies to improve access to reproductive health care services. So I'm really excited to have this conversation. It has been quite a year. We're about 1 month shy from the 1-year anniversary of the U.S. Supreme Court's Dobbs versus Jackson Women's Health Organization decision. That decision, if you haven't been paying attention, overturned Roe versus Wade and Planned Parenthood versus Casey, and held that there is no constitutional right to the right to abortion. That decision also overturned over nearly 50 years of precedent, and it purported to leave the states with the authority to regulate abortion access. I remember being at ACS last year, and I was sitting in the audience in the big plenary room, awaiting the decision, hearing from Justice Sotomayor, right? And the decision actually came 1 week after the ACS conference last year. And I will just say, and I'm going to ask each of our panelists to briefly describe where they were on that Friday, June 24th. But for me, that was such a salient moment because if you remember, most Supreme Court cases that are either controversial or have great heft are decided or released, the decisions are released on the last week. So we actually were planning to be in the office all week, that final week. I thought, well, which one's going to be last? Is Dobbs going to be last, or is it going to be the Bruin case that's last, right? And shockingly, although we have been, every single decision day we were on the computers, looking. I had SCOTUS blog on one side and the Supreme Court webpage on the other, and so many people were on every week, every decision day that it just kept freezing and freezing. And that Friday morning, I was convinced. I had joked with my coworker, should we go in because are they going to surprise us and release it? And I was like, no. And then I see on SCOTUS blog, Dobbs is released and it's at Alito. It's an Alito opinion. And then I just, obviously, as we all know from the leaked opinion, not much had changed in the original and from that leaked opinion. And so it was a really difficult day, obviously, for everyone in this country. It was the first time the US Supreme Court took away a fundamental right from Americans. It was a very difficult day for our healthcare providers who were already tackling a very difficult landscape. And it was a really difficult day for all Americans. So I'm going to pass it on to just kind of ask the panelists briefly where they were on that Friday when they heard that the US Supreme Court had overturned Roe.
So, yeah, I feel almost like I'd blocked that day out a little bit before you presented this as the starting off question. So, I was actually in San Diego, California. My organization was test running a 4-day work week, which we now actually have, which is amazing. But so Friday for me was a weekend, and I did something I don't usually do. I left my work computer at home. So when the decision came out, it was a little nerve wracking. I'll get into the emotional side of it, but it was nerve wracking for me and really great that my boss was very understanding because the plan was to send out an email from me to our RJ Lawyers Network the next day after. So not that Friday, but that Saturday. So everyone was really helpful and patient with me to like figure out how to review it from my phone or read it to me. And so, but I was in San Diego visiting my great aunts and I was with my mom. So my mom started working in reproductive justice before we had the term kind of coined reproductive justice. So as a Mexican immigrant in Los Angeles, she was working in reproductive rights and justice in the 1970s. And we were visiting my great aunts who were born in Mexico and in a country where there wasn't access to abortion. And, they're making a few small strides towards access in Mexico while we're taking some steps backwards. Not to say that, access is still different in those two countries, but a lot of that was just on my mind. It was really hard to be with my mom who had worked on this. And 40 years later, she actually just couldn't even talk about it. We just went to the beach and relaxed for a little bit. And I had to sort of process it and really face it the next Monday afterwards.
So I was in DC and we had some friends from the Bay Area visiting us. So we were piled into the minivan, 4 adults, 4 kids, a couple teenagers, trying to tour DC, and then saw on my phone that the decision came out. So we immediately drove to the Supreme Court, parked the car, dragged the kids, and went to the protest that was brewing at the Supreme Court. And it was like literally within the hour, I think, after the decision release. So it was still small. People were still showing up. But that gave me a bit of hope. It was otherwise a dark day that people were ready to resist. So that's where we were.
Thanks.
And like many of us, I know, like Jenny, since we have a similar role. I was sitting in my home computer refreshing SCOTUS blog, and just confirmed, saw that it was Alito, knew what it was, and went to work, which for Planned Parenthood was, my colleagues were really astonishing in terms of getting right to work and litigation, in terms of organizing response, and also the providers who in many instances had a pivot right away. As Jenny said, it was we were ready, but we also expected it to be the following week. So it was a surprise. And I was really, amazed, as I continue to be, by the work everyone did in response.
Carrie, so you mentioned the work in response, and I'll just share since we have similar roles. Not only was it processing that decision that day, that night, I immediately went to work on filing a case in Louisiana to block that trigger ban. Trigger bans, for those of you who don't know, are these special breed of laws. They are statutes that spring into effect if and when the Supreme Court does something, and that was overturning Roe. There were 13 states that had these trigger bans, and organizations like Carrie's and mine and the ACLU went into immediate response mode. So it's difficult to process. But I wanted to ask you, Carrie, can you just kind of dive into what your patients and providers were going through on the heels of Dobbs, kind of the litigating approach within the hours and days after the Dobbs decision, and kind of give an overview of where things stand today?
Sure. And I think all knew, or most lawyers following knew that, but I think what the general public didn't realize was just how quickly the cards were going to fall after Dobbs. Nothing needed to happen for many states to ban abortion. In addition to the trigger bans that Jenny mentioned, there were some states that still had their pre-row bans on the books. And in some instances, they were enforceable right away. There were a number of injunctions of bans that also state AGs moved to lift relatively quickly. In some instances, courts hopped in and did it sua sponte without waiting for someone to ask. That happened at least in one case, and so there was nothing that was needed, which meant that folks who were trying to maintain access needed to file cases and file cases very quickly. And so we didn't just let the bans take effect. And so since Dobbs, the folks litigating in this space, there have been state court litigation bans in more than 20 states. Many of which were filed really in the weeks right after Dobbs. And many of those cases remain active. There are a number of different claims that we and others have been making in those cases. Many of them are working to establish a state constitutional right to abortion under a number of state-specific theories, whether it be a right to privacy or another source of state-specific rights. As folks know, a number of states have their state constitutions provide more protection than the federal constitution. In some cases where it was clear that that wasn't an option, we challenged the trigger itself. The trigger bans took effect upon either the Supreme Court taking action or sometime after, and there was an opportunity in some places to argue that those triggers were vague or violated procedural due process in some other way. And in some cases, we were able to argue that in the case of a pre-Roe ban, if it remained on the books, that subsequent legislation regulating abortion had impliedly repealed or changed the law. So as a result of this litigation, I believe that abortion bans are blocked by injunctions right now in 7 states. In addition to that, Michigan's pre-Roe ban was blocked prior even to Dobbs falling, and then was later repealed by ballot initiative in November, which is amazing. So many of those are not final rulings, so that they could change, but for the citizens in those states, it has meant a lot. But obviously, those successes can't change the fact that what has happened since Dobbs is nothing short of devastating and gets worse really by the day. Abortion bans have eliminated some or all abortions in 19 states. 14 of them are complete bans, largely in the South and Midwest. Nebraska could be added to the list because as we speak, the legislature is considering a 12-week ban. There was a huge blow to access earlier this week when the North Carolina legislature overrode Governor Cooper's veto. North Carolina really has been a huge access state post Dobbs, given the bans in the states around it. Currently has abortion available to 20 weeks. And the new law, when it takes effect, will ban abortion at 12 weeks and further restrict access to care in other ways, requiring 2 trips to get an abortion. So not only banning abortion, but also making it far more difficult for the patients who are traveling to access care. In terms, again, as I said in the opening, I think has been obviously it's devastating for patients seeking this care. And I think that the provider community in this country has really just been nothing short of astounding and resilient, as they always are, in working to provide care to as many patients as they can.
Yeah, it's really tough. I'll just share that these were facilities that have been around for decades that had, stalwarts in their community. It's where people got abortion care, their annual exams, where trans care was it was a healthcare facility where trans care was the only care that was provided in that state. And so many providers now don't exist there. Places like in Louisiana, our clinic client who has shuttered their doors was providing OBGYN training for 3 out of the 4 medical programs in that state. So now you can imagine that there's no training for medical residents in OBGYN care. And that's a really, really frightening thing on top of kind of the devastation of just healthcare being shuttered in many places. So I just wanted to shift over to just talking about how disastrous the court's decision was or is for pregnant people and healthcare providers. So, Professor Manian, can you describe some of the broader healthcare implications in this post-Dobbs landscape and what is happening in the public healthcare space for pregnant patients and healthcare providers this past year?
Sure. So we know from public health research that being denied a wanted abortion threatens women's health. There was a study out of UCSF called the Turnaway Study that found that women who are unable to access a wanted abortion experience long-lasting health harms from being forced to carry the pregnancy to term. And 2 women in that study who were denied abortion care died following childbirth. Now, that study was pre-Dobbs. What we know from the most recent data on the impact of abortion bans post-Dobbs is that there has been a significant reduction in the number of abortions that are happening. So more women and pregnant people are being denied a wanted abortion and are suffering these health harms. The Society of Family Planning, a research organization, has conducted a study called the We Count study. That study estimated that in the 6 months following the Dobbs decision, an average of about 5,400 fewer abortions happened each month in the US. So that in and of itself is a huge public health impact on people who are seeking abortion care and not able to access it. But what we're also seeing post-Dobbs are public health harms that reach even more broadly. Abortion bans are obstructing access to health care for people who are not even actively seeking abortion care. And this is happening in a wide range of areas. It's happening when it comes to pregnancy-related care, like miscarriage management, and it's happening beyond that with non-pregnancy related care, like female rheumatology patients who aren't able to get their arthritis medication because it could potentially harm a fetus. So the most harrowing stories, though, in this regard have been from patients suffering pregnancy-related complications who have not been able to get timely care due to state laws restricting access to abortion. So many of these laws have very narrow exceptions for health or maybe the life of the pregnant person. But because the language in these laws is so vague, providers are afraid to or being told they cannot provide needed abortion care. So there have been a handful of lawsuits that have been filed seeking to alleviate at least some of these public health harms from abortion bans. In Texas, 5 women filed a lawsuit under the Texas state constitution alleging that they were not able to obtain care for obstetric complications due to Texas's abortion bans. One of the plaintiffs in the case described how her doctors basically would not provide the standard of care for her miscarriage due to Texas's abortion laws until she became septic. She had 103-degree fever. She was in the ICU for 3 days, and she lost one of her fallopian tubes. Now, there are at least 100 stories like these in the media, so that means there are thousands upon thousands of these stories happening on the ground in emergency rooms and in doctors' offices around the country. In order to address these growing concerns, at least with regard to, urgently needed abortion care, all abortion ban harms people's health, but especially in cases of urgent care, the Biden administration issued new guidance under EMTALA, the Emergency Medical Treatment and Active Labor Act. And what this guidance did is assert that EMTALA can preempt a state's abortion ban, at least to some narrow extent, and that hospital emergency emergency departments are under federal law, are required to provide abortion care under circumstances that fall within EMTALA's protections. But two federal district courts, one in Idaho and one in Texas, issued conflicting decisions on whether or not EMTALA preempts their state's abortion bans, and these cases are under appeal. So we have all of these legal uncertainties around access to abortion care, even when the patient's health is at immediate urgent risk. Because of this, UCSF undertook a new study called the Care Post Roe study, asking healthcare providers to share their stories on how abortion restrictions are reshaping the delivery of healthcare in a wide range of areas. So the Care Post Roe study just issued some preliminary findings, and the study found that in the states with abortion bans, healthcare providers have been unable to provide the standard of care in a timely manner for a whole range of obstetric complications and even in non-pregnancy related cases. So one of the stories described in the study, a physician described how an abortion was denied for a patient who had ruptured membranes at about 16 weeks of pregnancy, early in pregnancy, well before viability. This woman developed a severe infection. She was in the ICU, and the physician described how the anesthesiologist was crying on the phone because they knew if the patient had to be intubated, she was not going to survive. The Care Post Roe study also found that healthcare providers felt moral distress when they were unable to provide evidence-based care, and some reported considering moving to a state where abortion was still legal. So in sum, what we're seeing is growing anecdotal and research evidence that abortion bans are causing denials of medical care where abortion is the standard of care for treating medical complications. So abortion bans are creating life-threatening medical emergencies where there need not be any if people could provide the standard of evidence-based care. So this is a public health crisis that is going to get worse because these bans are placing doctors in an ethical bind. They're stuck between a rock and a hard place, between their ethical duty to their patient and being criminally prosecuted for just doing their job. And the fear is that more and more providers are going to flee these abortion ban jurisdictions, which is going to further decrease access to maternity care for everyone. This is already happening. In Idaho, it was recently reported two hospitals shut down their maternity wards. And one factor was, they said, the political climate in Idaho. They cannot recruit providers to provide maternity care. So going forward, we are going to see more jurisdictions where people will not only be unable to access abortion care, they will be forced to give birth in unsafe conditions due to this shortage of OBGYNs. As we know, the U.S. has already been facing a maternal mortality crisis, and that crisis is borne disproportionately by women and people of color. So what we're seeing in the year post Dobbs is a serious public health crisis that impacts not only the people seeking abortion care, but any person who is capable of becoming pregnant.
And I will just share that as soon as Dobbs was overturned, I had a conversation with my husband where we said, if we were pregnant at the time, I would not be able to go to some of the states that I litigate in. I would literally not be able to do my job because that is the kind of harm we could not be sure, right, that I would be worked on. And the center actually published a report in Oklahoma. We've been filing cases like the one you heard about in Texas, but in Oklahoma, there was a woman who drove to 3 different hospitals, was turned away while she was bleeding, told to wait in the parking lot of the last hospital to bleed even further before a doctor could be sure that they would be able to work on her. So that's the status of being pregnant in America in the year 2023. These horrible outcomes are awful, but they're nothing new. Even before Roe was overturned, you've heard that so much of abortion access depended on your means and where you live. Specifically, states around this country for years were passing bill after bill, getting more and more extreme, either attempting to ban abortion, even when Roe stood, or just piling on restriction after restriction, putting more patients and providers at risk. So, Melissa, can you tell us about the disproportionate impacts that this had on various communities before, now, and after Dobbs?
Sure. Well, first, thank you for that question. I think it's a really good question. And it's important on this panel to note that Dobbs, as was mentioned, was one of the first times the Supreme Court revoked a right. And so revoked that federal right to abortion and laid the groundwork for states to create abortion bans. But that's a very different thing than access, which is something that we knew many people were living in communities in states that were already living in a post-Dobbs, Roe overturned world. Or they were living in communities where Roe never was protective for them. And so Dobbs is making it more expensive. It's making it more difficult and lengthy for some people to access abortion. But already it was impossible for some individuals in this country to access abortion. We know that the groups of people who had been targeted with greater barriers and institutional hurdles that they had to go over in order to access abortion were communities of color, people of color, immigrants, young people who relied on public insurance. The Hyde Amendment is included every single year in the budget and carves out abortion as part of pregnancy-related care. So anyone who's on public health insurance has to pay out of pocket for their abortion. So that's a financial problem. And then they're likely living in states where they have to travel to other places and navigate so many different barriers in order to access that healthcare, to exercise their reproductive health decision. So there are some specific disparities that have been exacerbated. Dobbs has certainly exacerbated some of those disparities. One place we can look at is there have been an increase in pregnancy crisis centers. And there's been an increase in funding, state funding, and even some federal funding for pregnancy crisis centers. And these are centers that are coercive and they derail someone's ability to make their decision about their reproductive health autonomy. We've already heard all of the different, North Carolina, I'll talk about that in a second as well, about the states that have added so many different hurdles to access abortion. And then you have crisis pregnancy centers where some individuals are going there thinking they're going to access care and instead are outright being lied to. And they're often people of color. They are targeting Black and Brown communities. And, something that's really important around this is to make sure that we are working to make sure that communities have access to the resources they need to actually have healthcare, culturally competent healthcare in their communities. So they don't have to go to other communities to access care. We should all be able to access pregnancy related care, including abortion, everywhere. And so, those are disparities, and disparities are really important. But what I want to shift the focus to is resourcing our communities to help work towards overcoming those disparities. And last night, I was really inspired. I think we all found last night's dinner so inspiring, so many of the different speakers. But one speaker really spoke to the work that If When How is doing in movement building among lawyers. And it was Representative Justin, who talked about proximity to different communities and working together. And so we are, as If When How, our reproductive justice lawyers network, working in proximity with communities. We believe really deeply that those who are most impacted should lead the work, but we also recognize that lawyers have skill set and have power that can be leveraged to work with communities to achieve some of those changes we are working towards. And so two examples briefly before I wrap up is that in Ohio, we're working with our lawyers in Ohio to connect them into a ballot initiative there that is meant to change the Constitution to protect the right to a spectrum of reproductive health care services, including contraceptive access, abortion, and infertility treatment. And so, we're working with our lawyers to make sure that they can volunteer and be a part of that ballot initiative process, that state-based action. But we're also connecting and making sure our lawyers across the country know about these different efforts. And glad that you mentioned North Carolina, because that's another space where we have seen that, really impactful change this week, where it had been a state that had access with states around it that didn't. And so, for example, South Carolina is one of the few states that does have a law criminalizing self-managed abortion. So they're navigating a lot, and we're connecting on the ground organizations to law firms so that they can navigate. They're at the forefront, serving people who are accessing, who are trying to get abortions, and so seeking abortions. And so we're trying to make sure that those who are serving people seeking abortion know their legal risk, know the liability, and they're able to continue to do so without criminalization. And so I think, it's important to acknowledge that there are disparities. There were disparities before Dobbs. There are still post Dobbs, but that if we work to build a movement of lawyers who are connected to those on the ground, who are impacted, who are leading the advocacy on the ground, that's a real key to achieving a future with reproductive justice.
Thank you so much. Since we're a room full of lawyers, I'm going to give the second CLE code. The word is cherry. Cherry. If you're looking for your CLE credit. And also, we're a room full of progressive lawyers and law students, and that means there are tough fights and you shouldn't give up, and none of us are packing our bags. But we also have to deal with the reality of where the courts are and what the impact of Dobbs means for future jurisprudence. So as you've heard, and to hammer it in, the Supreme Court for the first time took away a fundamental right from Americans. It said that purportedly to return the quote unquote abortion issue back to the states. It also hacked away at substantive due process of the 14th Amendment, and displaced, I won't go into it because that's a whole other panel, but Planned Parenthood versus Casey was a case. If you strip the word abortion out, it's about how the U.S. Supreme Court follows precedent, right? It gives an entire formula and it's like a roadmap. And now that framework theoretically has been somewhat tinkered with, and now we follow a case called Glucksberg and the Dobbs framework. And much of this now rests on a version of quote unquote history and tradition. So what does this mean for people who are litigating in this space, right? How can you rely on the Supreme Court or the court's interpretation of the Constitution to support civil rights and liberty just generally? And what are the limits of courts as the arbiter of such rights in the future? Carrie, do you want to start us off there?
Sure. Thanks, Jenny. I could probably talk about this for several hours, as I'm sure many of you in the room can. But I just two sort of quick observations. One is that despite the court, the court announced that it was sending the issue back to the people's representatives, claiming that the Constitution, particularly Justice Kavanaugh, his concurrence that it was neutral as to abortion. We always knew that our opponents were never going to stop just with overturning Roe. And the case that many of us have been following this year is, the Alliance for Hippocratic Medicine case, which was filed in Texas, notwithstanding the fact that abortion is banned in Texas, in Amarillo, Texas, with Judge Kaczmarek, the goal of which is to obtain a nationwide ban on mifepristone, which is used in over half of the abortions in this country, and obviously would impact really nothing or not much in Texas, and instead would ban more than half of the abortions as they're performed in the rest of the country. So the goal, our opponents made clear very, very quickly, because that case was filed in November, that the goal is to ban abortion nationwide. Obviously, the Supreme Court stepped in a few weeks ago and issued a stay while the case proceeds. But the oral arguments were held on Wednesday in the Fifth Circuit on the appeal, and were rather astonishing, I would say, in terms of the panel accepting the allegations of the plaintiffs in that case, even though they're not grounded in the science, and the science has been carefully considered by the FDA in approving this medication over 20 years ago. And since then, it's been used by nearly 6 million patients. And so that's just one observation. Secondly, as Jenny mentioned, the reliance on history and Justice Alito. Actually, this is Dobbs right here. A lot of this is his appendix with the laws. In effect in the states when the 14th Amendment was ratified. But the view is because abortion was not a right in the 1860s when the 14th Amendment was ratified, it is not given protection by the Constitution. Now he went on to say very clearly that abortion is different than other rights that the court has protected, including marriage and contraception. And he said it's because abortion is different because of fetal life, but there is no limit in terms of the courts, in terms of the the analysis that the court applied, and so it is also clear that opponents of sexual and reproductive health care are targeting other things, including contraception. Justice Thomas's dissent in particular says he just doesn't buy that there's a substantive due process protection. And the dissent in Justice Roberts' concurrence really, I think called out the majority for saying that there's a limit to abortion, but there not being any clear limit in the jurisprudence. And so, we have even seen that the threats to the other rights play out. Judge Kaczmarek, who's the district court judge in Amarillo, who has the Alliance case, had another case this year that was a challenge to Title X, the nation's family planning program's longstanding protections that minors can get care without parental consent. Case that was brought by Jonathan Mitchell of SB 8 in Texas fame. And in that case, Justice Kaczmarek actually referred to, said something along the lines of the right to contraception being at risk, citing Thomas's dissent.
Yeah. I'll just add, the dissenting opinion in Dobbs used this metaphor that our privacy rights, and I think our civil rights under the Constitution in general, are like a Jenga tower. And Dobbs just pulled out this core block and the whole tower is shaking. And we need to pay attention to what other blocks are going to get pulled out. We see how this abortion block is shaking contraception, LGBTQ rights, racial justice, affirmative action is going soon, voting rights are going soon. These are all connected. I've been teaching constitutional law for over 15 years. It has changed a lot in that time. And, I think I and many of us were living under the shadow of the Warren Court, where we saw the court as a protector of our civil rights. But if you look at the whole 200-year history of the U.S. Supreme Court, it has more often than not been regressive. This court that we have now is certainly not going to be a protector of our civil rights. It's dismantling everything that was built under the Warren Court for civil rights. So we really need to see how all these issues are connected and build coalitions between reproductive rights and other related issues. And while courts are very important and we need to think about how to reform the Supreme Court in the long run, we need to look at other avenues beyond the court in the short term and in the long term to rebuild and protect civil rights.
Thank you. Before we go to our last question for the panel, before we do Q&A, I do want to just add, if the court's analysis, no matter what that single sentence said, that Justice Alito doesn't want to go after other cases, if the analysis holds, it's a roadmap for every single 14th Amendment substantive due process case. And if you look at that version of history and tradition, putting aside that it's cherry-picked, if you did not have rights in 1868, this U.S. Supreme Court, the majority of the court does not believe that you should have them. So I want you to ask yourself, are you a woman? Are you a person of color? Are you a white man, but you don't own property? Then I'm sorry, right? That is how little we have come from 1868 to 2023. with that, let's talk about lessons learned from this past year, because obviously lawyering strategies need to change for reproductive rights, the advancement of reproductive justice, and the enhancement of protecting reproductive health in this country. So, how can we be more responsive to the history and experiences of all communities to further better? And Melissa will give you the last word.
Great. Yeah, I actually just want to echo what Professor Mannion said too. So I think this past year, organizing and mobilizing lawyers in this country in a post-Dobbs world has really reinforced my belief that the approach needs to be multi-pronged and it needs to be coordinated. And so I just want to uplift what was mentioned about coordinating among issue areas, so that intersectionality, definitely coordinating within the reproductive rights and justice space. I think we need to sort of up our coordination and communication among our strategies. And I actually think If When How is a great example of the idea of having a multi-pronged approach. So I organize and mobilize and educate nearly 2,000 lawyers in this country who care about reproductive rights and justice. And I think being responsive to the history and to the experiences of reproductive oppression, step one is education, learning more about the experiences of those who've had reproductive oppression targeted at them. And I think coming with an open mind, recognizing something from a broader context is really important before running out there and spearheading forward. I think it's important to learn from those communities who have experienced reproductive oppression and why there's a reproductive justice movement. And specifically, the term and the outlook was rooted in a group of Black women in the 90s. And so really learning that history. And I think that also we have a litigation department, criminal defense team, we have a policy team, and we also have a helpline where people who are seeking abortions can gain access to legal information, not legal advice, but legal information. And so we also have a legal defense fund. So having that multi-pronged strategy, those immediate needs being met, and also the longer term movement and approach. And I always try to shy away from the word fight, but I guess that is how it feels right now. That longer strategy that we're in this for several decades to come. It's not just the immediate, it's that both have to happen at the same time.
Thank you so much for that. And I really want to remind, right, as this panel even says, this is 1 year later. And folks who wanted to overturn Roe worked on it for 50 years. And personally, I hope it's not going to take that long, but we also have to steel ourselves that it's going to be a long battle and there's going to be ebbs and flows as all fights for justice. But it's not going to be, people want a solution right away, and it's going to be a multi-pronged approach, leveraging all the strengths of our community. With that, I would like to turn to Q&A, and I'm instructed to tell you all that there is a microphone there, as you see. Please walk towards it if you have a question, and you must use the microphone for the recording quality because this session is being videotaped. And please have your questions be short and actual, and if you would like to direct it to someone, please go ahead and do so. Okay, go ahead.
Hi, y'all. Thank you so much for being here. My name is Alyssa Craze Aubrey. I'm at the University of Houston in Texas, so I'm very stressed all the time. I'm also president of my If When How chapter at UH, so so if someone could explain a little bit about the proposed HIPAA privacy rule that has come out. I don't know a ton about it, but if any of you guys have a little bit more sense of what that could mean going forward for covered entities and their business partners, having a little bit more control over the information that is turned over to authorities in situations where people are accessing justice legally.
I can start, and then I can also connect you with other resources who know more about this than I do. But thank you for what you're doing and hanging in there in Texas. I think that so there's a new proposed rule that defines reproductive health care broadly and would impose limits on the ability of providers to provide sensitive reproductive health care information upon request to law enforcement. And so it's, has been a very significant and important movement toward electronic health records and sharing that is generally important for health, but obviously poses a lot of potential risks to patients, particularly navigating a post-Roe world. And so I think that the changes that have been proposed are an excellent step. It's in a comment period right now. And I know there are organizations collecting comments. And so if you're interested in that, let me know. And please, come forward after and I can connect you to some resources.
This isn't quite about HIPAA, but I did also want to mention on this panel the SHIELD laws that blue states have been passing. I think we're up to 17 SHIELD laws now. And one of the things that SHIELD laws can do is ensure that a provider who provides legal abortion care in their state, so say they are in Oregon and provide an abortion in Oregon to, say, a patient who's traveled from Texas. If that patient goes home to Texas and then there's some sort of Texas action, the SHIELD law will say that Oregon will not participate, will not give information or participate in the Texas action, which normally there would be interstate cooperation, but the SHIELD law says we will not cooperate in abortion prosecutions or civil lawsuits.
Thank you so much. We will take the next question. Go ahead.
Thanks. My name's Jeffrey Blackwell. I'm with American Atheists. And in light of the fact that, like you said, this is likely to be a decades-long fight to regain rights that we thought were pretty well settled, and that a lot of what we're going to have to do is going to be outside the courtroom. In terms of non-litigation advocacy, I'm curious, is there salience to the idea of, is there salience in pointing out to people who have not been swayed one way or the other by the arguments presented yet, that that a state or a government with the authority to tell you you cannot have an abortion is also a state with the authority to tell you you must have an abortion?
I'm not sure that that's a strategy or tactic we're necessarily taking on, but I would love to mention culture shifting right now, the importance of we're a room full of lawyers. We talk about rights. We recognize that this is not just right, it's actuality, and there's a lot of logistics. There are abortion funds out there that have practical support that are getting folks to those other states. And I think it's important for us to start talking not just in legal terms, but in actual experiences and talking to everyone outside of this room so that we can shift the conversation. And I also think the multi-pronged approach is we feel devastated by this, but that doesn't mean we shouldn't continue moving forward around sex education and shifting the next generation's outlook on sexuality, on gender, and on abortion.
Absolutely. We'll take the next question.
Hi, my name is Neka. My pronouns are they, them. I think it's pretty clear that the anti-abortion move or the anti-trans movement is taking a lot of pages out of the anti-abortion playbook. And so I was wondering what lessons and advice you think that pro-trans advocates should be taking from the pro-abortion movement.
Great question. Do you want
Sure. I could say one thing when I was talking about culture shifting is abortion storytellers and sharing their stories. I think there's a need. I agree it's multi-pronged, but I always think storytelling and sharing and humanizing of all of our experiences is really important. I think I'll pass along if you all have some tactics like policy-wise or litigation-wise.
Yeah, I think given that there's not much hope in the courts in a lot of ways now, and maybe a lesson learned from the abortion rights movement, not to criticize anybody. I used to be a litigator at the Center for Reproductive Rights too, is we were too court focused. We were too court heavy. And so I think that's maybe a lesson learned of what not to do. And that the culture shifting and the education and the storytelling is really, really an important part of the advocacy.
Great. Thank you. Next question.
Hi, I'm Olivia Fisher. I am a recent graduate from North Carolina Central University in North Carolina. Our shield protections have been tied to an executive order with our Democrat governor, and it seems likely that in the next election cycle, the executive office will change in the state. What are the consequences we should prepare for as a major state provider for the South in terms of providers being at risk for extradition after we see a change in leadership?
It's a fraught area. I mean, I don't have a crystal ball. I would say just if you have still the time, right, push and advocate for, your wanted candidate to win. We can win on this issue as well. I just told someone, we're batting 1,000 when it comes to abortion. We have the president saying the word now, other folks saying it. So that's all positive steps. That said, this area of law is going to be incredibly fraught. That is what the Supreme Court did when it overturned Roe. Whether or not the shield law remains, there will be challenges. There will be, unfortunately, pregnant people who are prosecuted. There will be providers and healthcare providers who are going to have their licenses stripped. This is unfortunately the reality of what will occur, and there will be internal state-to-state fights. So the only thing I know for sure is that there will just be a lot of uncertainty before there is like any of this dust settles in this area.
Yeah, and I just would add, I'd like to put in a plug, I guess, for the Abortion Defense Network, which is a group that has come together post Dobbs, coordinated mostly by the Lawyering Project, but involving other litigating groups and a number of national law firms, that is available to answer questions like that and many others, particularly coming from the provider community.
Okay, I see one more person. Don't be shy. We probably have time for a few more questions. Go ahead.
Hi, my name's Mary. I'm a rising 2L at the University of Wisconsin-Madison. I was just wondering, since I know you guys all have spoken to how this is, the beginning of pulling a block out of the Jenga Tower of substantive rights for due process. And I was wondering if you've seen, I guess it's a little bit more of a question for the litigators, litigation using the Dobbs decision to already like chip away at those other rights. Or I know you've talked about different district court cases throughout the US, if that's like really starting to seep into other areas, and if so, if that's informing your work at all.
I haven't seen briefing using Dobbs. I mean, I've seen it mentioned for other purposes, but not as the kind of blueprint I was mentioning, right? To chip away at stare decisis and take away substantive due process rights. The scary thing is, though, that those cases are in the pipeline. So if the court were to decide to take cert on those cases, right, certainly it can apply the Dobbs-Glucksberg analysis onto those cases. So, I mean, that's where I kind of land. I don't know if I've seen particular briefing being like, use Dobbs to get rid of Obergefell.
It's coming.
Yeah. Thank you for your question.
Hi, Meredith Kincaid from Atlanta, Georgia. I know we've got a group of women who are exceptional criminal defense attorneys, work in the healthcare space, and are kind of sort of chomping at the bit to do something, want to be clear that, happy to represent anyone who ends up coming under, facing criminal charges or any kind of, whether it's from a provider or an individual, anything like that. How would you suggest that we sort of get plugged into? I'm sure that there's already conversations about that, wanting to make sure that, we can get connected to people to make sure that y'all know that we're willing to do that.
Definitely come up and give us your card after. The Abortion Defense Network, which you should plug into.
Okay.
And for those of folks across the country who aren't from DC, we are always looking for law firms to partner with, especially for local counsel purposes as well. But we should definitely talk.
Yeah, and IFWNHOW also has a criminal defense team too, and we have a criminal defense network. So we provide trainings for criminal defense attorneys on the strategies. We only represent people seeking abortions, so not providers. But on that side, we can definitely connect as well and link you in.
Cool.
But this is a great example of how it really does take a village. It's talking about like our expertise in different roles, but for you guys to go out there and like honestly rabble rouse at your Thanksgiving tables, right? Abortion is very popular. We've said it before, Dobbs, and now it's been proven. Again, we're batting 1,000, right? So talk to folks about it and try to frame it in different ways, not whatever imagery your uncle might have of who goes to get abortion care, right? But 1 in 4 people who can become pregnant have had an abortion. You can point to people who have been experiencing obstetrical emergencies across this country. You can make the example, like, right, of like if I were to go somewhere, if you got pregnant, like you would not be able to go to certain states in this country right now. So that is the reality. And I think just talking to people, it is popular. It is something that people should know about and care about because it affects everyone of all genders. And it's about families and how you construct. And we all have histories and reproductive lives. And we'll take one final question.
Hi, I'm Danny Bayongarstad. I live in Baltimore. Just one question. Is there any appetite from any of your organizations to litigate abortion rights through provisions of the U.S. Constitution that are not foreclosed by Dobbs? Or are we kind of giving up on the federal courts for a time?
I feel like reasonable minds might disagree here. Maybe not, maybe unreasonable minds. I mean, my opinion is that you cannot completely secede ground. There is real value to building a district court record that is also careful, of course, right? You have to take care because of what the federal court landscape looks like. And if in this particular Supreme Court, we know who the justices are, and they were folks who were majority willing to overturn the right. There are other constitutional elements, even with the 14th Amendment, right? Equal protection is one that's been talked about quite a bit and made a brief showing in the Dobbs decision, but not fully. I know that in the First Amendment panel this morning, abortion was discussed because abortion's everywhere. And so, yes, of course, there's other constitutional rights that can make its way through. That said, right, I'm someone who would not give up on the federal courts, but be incredibly cautious and strategic about what cases to bring when and how. Okay.
Yeah, I would just echo what Jenny had said, and obviously what she'd said before about hopefully this is not a 50-year project, but the arc of this is going to be long. And I don't think, despite the subtle jab at litigation earlier, I don't think that litigation is certainly not off the table as part of the package of strategies to restore the right.
And I would just add, given these strategic concerns about going to the court, there are other places to develop alternative legal arguments. Academic scholarship is one of them. So as a professor, I should mention that. But people are developing arguments in scholarly literature that eventually make their way into the court. So if you look at conservative legal arguments, original meaning in Dobbs, that came from Justice Scalia's academic work. Second Amendment rights, that was built partly through a lot of scholarly work. So there are legal scholars developing First Amendment arguments in favor of abortion and other reproductive rights. Michelle Goodwin, who's an amazing scholar, is working on 13th Amendment arguments, bringing this intersectional perspective on race and gender as a basis for protecting reproductive rights. So there's other ways to sort of build the ground for alternative legal grounds for reproductive rights in all kinds of different venues. And it's a long game. So we have to try every possible avenue.
Yes. And true to our word, we're only 1 minute over. So thank you so much for being here on this